Welcome once again to Lehto's Law. Here's Steve Lehto.
The folks at the Institute for Justice have been busy lately doing good work. I got a note from them yesterday. Court rules in favor of Georgia nonprofits' challenge against Calhoun's ban on building small homes. So attached to that press release was a note. Steve, I just wanted to let you know we've received the official written order for tiny homes. Hands ups win. The ruling confirms the government lied to the organization by claiming there was a minimum square footage requirement when in fact there was no such requirement on the books. And that's actually a very, very interesting angle in this case. We'll get to that in a second. So it was only months after they denied this group the permits that they put such a requirement on the books. So the court wrote in its order about this, but let's back up. The organization Tiny House Hand Up won an important legal victory in their challenge to the city of Calhoun's ban on building homes smaller than 1,150 square feet. The organization is a nonprofit that wants to use donated land to fill a niche for smaller, less expensive homes. After the Institute for Justice argued on their behalf, the judge ruled from the bench granting a motion in their favor, and then a written order came out confirming that they will be allowed to do this. This is not just a win for our clients, it's a win for the people of Calhoun, says IJ attorney Joe Gay. The city spent years telling them that they can't build modest cottages on their property. We are thrilled to finally have their constitutional rights vindicated in court. Small homes offer flexibility for people who might not be able to afford larger homes or who just prefer to downsize, says a senior attorney, Dan Elbin. Imposing arbitrary limits on home size makes no sense and violates the Georgia Constitution. Affordable housing is one of the most pressing economic issues facing Americans today, with soaring prices keeping people from obtaining the American dream of housing independence. Even some people with a steady job but modest income are unable to afford housing in today's economy. Between 20 and 2024, the median house price in Georgia rose from about $250,000 to over $380,000, the median house price. Calhoun specifically has wrestled with affordable housing. Its poverty rate is more than double the national average, and its rate of home ownership is lower by 36%. Now, it shouldn't surprise you that almost 20% of homeowners and 40% of renters in Calhoun live in housing that costs more than 30% of household income. And that 30% is often the benchmark that people say you should not be spending more than that on your housing. And if you are, you're probably struggling elsewhere. So IJ has successfully challenged arbitrary laws that prohibit people from using their property in ways that people have always used their property, such as growing vegetables, running small businesses from home, and baking and selling food from a home kitchen. Government busybodies increasingly want to dictate not only what you do on your own property, but also what kind of home you're allowed to live in. IJ stands ready to continue to help property owners fight these increasingly intrusive and irrational regulations. So the note I got yesterday mentions that this group got a piece of property and they wanted to build some small homes on it. They approached the city and said, "Can we do that?" The city said, "No, you can't. No, you can't. Because we have a rule about a minimum square footage, and the small homes be less than that." But then they told them, but what you should probably do is ask to have it rezoned and then apply for a variance. So they asked to have it rezoned, they applied for a variance, and they said, no, you can't have a variance because the homes are too small. But in the meantime, the city realized that they had no minimum square footage requirements, at least not on the books, so they very quickly put one on the books. And the opinion from the Superior Court is fascinating. It's only 8 pages long. But in it, the court wrote, the Calhoun city administrator, however, expressly told Tiny House Hand Up's executive director in August 2020 in an email that the district does not permit homes smaller than 1,150 square feet. Based on that statement, the organization sought and obtained the least restrictive single-family residential zoning available, and the city then issued a moratorium on new applications, which remained in effect when this case was filed. Soon after, the city amended its zoning code to expressly forbid homes smaller than 1,150 square feet. And so they actually lied about it. So that was an interesting point made by the court, because they then ruled, the court did, that it was a procedural due process violation. The government may not mislead parties to their detriment. It is therefore unnecessary to analyze whether and what kind of detriment actually exists. As the court ruled from the bench, first, the undisputed facts show the city officials misrepresented the requirements of the zoning district to plaintiffs' detriment, establishing grounds for equitable estoppel. I'm not going to try to explain what equitable estoppel is, other than to tell you that if a party takes one position and it gets you to behave a certain way, later on they can't say, oh, that's not our position anymore. Well, if you've relied upon that to your detriment, it sure as heck is your position, especially when you're in the government telling people what the law and what the various codes are and what you are and are not allowed to build on property zoned a certain way. One of the other fascinating things about this case, and I almost hate to bring this up because people are going to think I'm making this one up, but if you read the case caption of what the court was ruling on, there were cross motions for summary disposition and to amend and blah, 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 blah. And at one point it says that the defendants, which is the city in essence, wanted to amend their response. And the court granted their request to amend the response and then immediately ruled against them. And my first thought was, why would the court do that? That's odd. But then you read the 8-page order, and in it, the court says, the city has asked us to allow them to file an amended response to this motion because their original response was partially drafted by AI and contained made-up citations. They're everywhere. Right now, AI is in this building making up citations, waiting for me to turn around and look the wrong way, and it's going to jam them into something. So the court actually said, we're going to let them do that. We're going to let them withdraw the original motion and response and let them file a new response that doesn't contain made-up hallucinated citations nor AI stuff. And they may have used AI to draft it, but somebody went in and cleaned it up, which they should have done in the first place. The good news for them is that they caught it, brought it to the court's attention, and immediately fixed it. But, of course, the fact they did it in the first place does make one raise an eyebrow or two. So, the point is that the people, the organization, are going to be allowed to build tiny homes on the property that they own. But one thing I'll point out to you, and I even believe the Institute for Justice would want you to know this, that this is a trial court victory. This is a victory at the Superior Court in Georgia. Obviously, appeals can happen. So when the judge first makes a ruling on the initial case, a first appeal is almost a gimme, unless the city actually wants to go, you know something, it's not worth it. But the good news is the Institute for Justice is into these cases for the long haul. They get involved in these cases at this level. They're willing to ride it out the bitter end, even if it goes to the U.S. Supreme Court, and they've done that before too. So I have to tell you, number one, an appeal, probably, likely, but we'll see. But number two, the Institute for Justice is a nonprofit organization that exists entirely based on the generosity of its supporters. So check them out at ij.org. Check out their channel here on YouTube. Subscribe to their newsletter. Follow what they do. Even if you can't support them financially, support them with a moral support situation. I've had people tell me, Steve, I can't afford to support them financially, but I follow what they do. And I think on some level that helps them to know that, hey, a lot of people agree with what we're doing. So if you can support them in any way, please do so. But thank you to the folks at the IG for sending that to me. There's been a victory at the trial court, which has ruled in favor of a Georgia nonprofit's challenge against Calhoun's ban on building small homes, which weirdly was passed after these people had already been denied building small homes. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Ladies and gentlemen, I've been to Vietnam, Afghanistan, and Iraq, and I can say without hyperbole that this is a million times worse than all of them put together.